for Come and Talk It with your host, Michael Cargill, brought to you by Texas Law Shield. Over the last decade, Michael has championed and supported the rights of law-abiding Texans to own and use firearms. He is the owner of Central Texas Gun Works, a veteran of the United States Army, and has achieved national exposure in such prestigious media outlets such as Forbes Magazine, Fox Business News, CNN Money, AOL, BBC World News, Huffington Post, and the New York Times. Cargill vigorously defends lawful gun ownership in this country without regard to party politics. And now, here's Michael Cargill.
Good day, Austin, Texas, the live music capital of the world. Let's praise the Lord and pass the ammunition. So the Bumpstock ban lawsuit has been revived. That's right, Michael Cargill versus the man. That's right, we're going against the Department of Justice. We're going against the ATF, and it is going to be heard en banc before the entire Fifth Circuit in New Orleans. This case is going to be heard in New Orleans, in court, not on Skype, live in the courthouse. It's going to happen, I'll give you that date a little later. Save it for a little later. But we will have this in court in New Orleans, heard en banc between all the justices. Basically what happened in December of 2021, this case was heard by a 3-judge panel, which we drew all Democrat justices. So those Democrat judges decided against our case. So now the entire Fifth Circuit has requested to hear the Bumpstock case before the entire court. And when that happens, that means they're looking to overturn the previous ruling. You know, if they agree with it, there would be no reason for them to hear the case. So once this case is heard in front of the entire circuit, it's overturned, then we're guaranteed we should be headed toward the Supreme Court of the United States.
Did you know that there are only 0.3% of cases in which en banc is requested that are actually...
That's why this is such a big deal. This is really big. And this says a lot because this happened after this case in New York, which we're going to have Edwin Walker on from Texas U.S. Law Shield to talk to us about New York State and what that actually means from what the Supreme Court actually released last week. We're also going to talk with Edwin about some other things as well. Also, do guns have more rights than women's bodies? Man, I've been hearing that a lot in Austin. Good Lord, it's like, you know, when you're living that liberal mecca, no matter where you go, what restaurant, bar you go to, boy, they let you know how they felt this week.
That is not how we do things in the city of Austin.
Let me tell you. So, you know, you just have to roll with the punches. And that's all I heard. Every time I walked in somewhere, Michael Cargill, do guns have more rights than women's bodies? Well, you know what? This hour, I'm going to give you that answer. Boy, and that's why I carry a gun. That's why...
Shut your mouth.
That's right. Because let me tell you, you're not going to like my answer. And you know what?
What's gonna get you for that?
I'm going to give you my answer right now. The Second Amendment is a constitutional right. Women's bodies are not. Also, Texas GOP and the log-cabin Republicans of Texas. Man, let me tell you, there's a lot going on with that convention and a lot of resignations. We're going to talk about that. About log-cabin Republicans of Texas, also the YRs. We're also going to talk about the homosexuality plank that was introduced and passed by the Texas GOP. Also, U.S. Congress, the anti-gun bill. Going to talk about that with Edwin Walker with Texas and U.S. Law Shield. And like I said before, New York State gun license and what the SCOTUS had to say about that. But you know what? You reap what you sow. A lot of people are just so upset. There are protests going on all around the country. They're angry because Roe versus Wade was overturned. And so you have protests in all the major cities around the country. And they're just like, do something. This is not right. It shouldn't be. Well, you know what? You know whose fault this was? If you're a Democrat and you're upset about the way this actually came about, the hearing, you need to blame Joe Biden for that.
Oh, come on, man.
That's right. It's Joe's fault. And I'm going to tell you why it's Joe's fault. Because President Joe Biden, back when he was a senator, was on the committee that actually got a chance to, decide if Clarence Thomas was going to be a Supreme Court justice. This happened back in 1991. And so he heard this case, and then someone came forward. Something happened. That was Anita Hill, a black professor, now a professor. At the time, she was a law clerk, I believe, and she worked for Judge Clarence Thomas, and he made some advances on her or suggestions or statements or whatever. And so she brought this up before Congress, before the Senate, the Judicial Committee, to say, hey, you guys should not pick this man as a Supreme Court justice. This happened in 1991, where Joe Biden at the time, the senator, was the chair of this committee. So he had the opportunity to stop this in its tracks. The reason I bring this up is because everyone's upset because Judge Clarence Thomas is the one that actually wrote the opinion of all these cases that we've heard the last few days. And so they're furious at him. I'm hearing, celebrities step forward. Samuel L. Jackson's going back and forth, saying things about, Clarence Thomas and all this kind of stuff. But you know what? They shouldn't be mad at Judge Clarence Thomas because he is doing exactly what he believes, and he's doing what he's always said he was going to do. There are no surprises there. You should be mad at Joe Biden. And here's why. Listen to Anita Hill and what she had to say back in 1991.
He pressed me to justify my reasons for saying no to him. These incidents took place in his office or mine. They were in the form of private conversations which would not have been overheard by anyone else. My working relationship became even more strained when Judge Thomas began to use work situations to discuss sex. On these occasions, he would call me into his office for reports on education issues and projects, or he might suggest that because of the time pressures of his schedule, we go to lunch to a government cafeteria. After a brief discussion of work, he would turn the conversation to a discussion of sexual matters. His conversations were very vivid. He spoke about acts that he had seen in pornographic films involving such matters as women having sex with animals and films showing group sex or rape scenes. He talked about pornographic materials depicting individuals with large penises or large breasts involved in various sex acts. On several occasions, Thomas told me graphically of his own sexual prowess. Because I was extremely uncomfortable talking about sex with him at all, and particularly in such a graphic way, I told him that I did not want to talk about these subjects.
This is Michael Cargill, and you are listening to Come and Talk It.
This is Coleon Noir, and you're listening to Come and Talk It with Michael Cargill.
He didn't act that way. He never flinched. He went for his pockets. And when he went for his pockets, I thought my heart was going to stop. I mean, Hi, my name's Jerry. The incident we're going to talk about took place in early March of 2017. It started back about 3 years ago. We had a fella in the neighborhood that nobody really knew. We weren't familiar with him, and he was pretty regular about speeding up and down the street. It escalated into more speeding, threats. He dunked some rocks up into the yard and broke my windshield in my truck, and it escalated from that into death threats. And he was constantly chirping about how he was gonna end it and he was gonna kill so-and-so, he was gonna kill me, and it was all chirping. The day of the confrontation, I was leaving the neighborhood and heading to a meeting downtown Fort Worth. It was a beautiful day, I had my windows down, I was in my Suburban. As I was heading out, just about to leave my neighborhood, this guy comes into the neighborhood, sees me coming out, pulls into my lane, causes me to stop, and then he kind of cut at an angle in front of me and jumped out of his truck and ran at the side of my Suburban, saying, "Today's the day you're going to die. He's going to end it." He comes over and he's slamming his hands up against the side of my vehicle, my truck. But he's screaming at me, telling me he's going to kill me. He's going to end it. This is the day I'm going to die. He reaches in to try and open up my door. I grabbed my weapon. I put my weapon right at his chest at the window and told him to get back, told him to get the hell back. And he never did. He never moved. He never changed anything. He went for his pockets, shuffling into his pockets, and he pulls out his cell phone. I drove off around and called 911 before I got to the end of my street. Yeah, I've carried a weapon for pretty near 20 years, and I've never had to pull my weapon out. Now, I can tell you that when you do that, it's the emotions are incredible. You feel the flush come through your body because you just pulled a weapon on somebody, you're pointing a gun at somebody, and they don't move. And that's a whole nother, they didn't say, "Whoa, stop," like anybody that you'd think would do that, but he didn't act that way. He never flinched. He went for his pockets, and when he went for his pockets, I thought my heart was going to stop. I was actually told that if he would have pulled out a gun, he'd have shot me before I could have actually pulled the trigger, and that's pretty awakening. I contacted Texas Law Shield and spoke with them and got a statement that I wrote, and I turned it in the following day. And
Welcome back to Come and Talk It. And now here's Michael Cargill.
All right, so I want to bring back into the conversation here, bring to the conversation Edwin Walker, who's the principal attorney with Texas and U.S. Law Shield. You know, if I have any issues at all, something happens with me, what I do is I dial 911 first, then I call my attorney. I call Edwin Walker to find out what I actually should do, because I'm invested in what's going on. The incident's happening to me, and I want to make sure that I say and do the right thing, and I don't get myself in trouble. So I call 911, then I call my attorney, and I let my attorney do the talking for me, Texas and U.S. Law Shield. And I suggest you do the same thing. I cannot stress to you how many phone calls we get throughout the week where people will do stuff, and they give us a call. I am not an attorney. I cannot give you legal advice. So I always recommend people contact an attorney, call Texas U.S. Law Shield, become a member before your incident happens. That way, Texas U.S. Law Shield can represent you. Don't wait until it happens, because then it's going to cost you. It's going to cost you a lot of money. But if you contact them and become a member of Texas U.S. Law Shield before it happens, you're only looking at $10 a month. So be smart. Defend yourself. Protect your family. And then let Texas Law Shield defend and protect you. Edwin Walker, I want you to, Edwin, tell us what in the world is in this U.S. Congress anti-gun bill, and when does it go into effect? Edwin, welcome to Come and Talk It, sir.
Yeah, Mike, thanks for having me. It's always great to be on your show here. So the bill, the thing about it is that I know that obviously Cornyn was looked at as a traitor, and the 10, Republicans were looked at as traitors, and Cornyn was booed at the Republican convention. But the bill itself, once you delve down into it, it spends a lot of money, and it requests a lot of commissions and a lot of studies. And, Cornyn, I've seen him do his press conferences. He's like, look, we are not affecting the ability of people to get firearms, and we're not affecting the firearms that can be received. And, technically he's true. It really doesn't do that. And certainly if you compare it to that atrocity that came out of the House of Representatives, House Resolution 7910, that is the type of bill that we always need to stay vigilant of, because that does do the things that we, basically the top three things that we need to always be aware of as gun owners. We need to be aware of any kind of proposed quote unquote assault weapons ban. We need to be aware of any kind of quote unquote high capacity magazine ban. And we need to be aware of anything that impairs the right of people to make a private intrastate transfer of firearms to one individual to another. Those are really the top three things that really I fret about the Congress making rules about. Fortunately, this compromise bill goes nowhere near doing any of that, and I don't think it provides an avenue for the anti-gun folks to do it later on just by simply amending this. So what it does do is, like I said, it spends a whole bunch of money. It commissions a whole bunch of studies. It tells where states and local governments and school districts can get money and how they can spend it, things like that. But what it does with regard to guns specifically is that it does not impose a ban on 18, 19, 20-year-olds having their ability to purchase a rifle. What it does do is it now says that certain juvenile records can be reviewed, and it does kind of create a de facto waiting period for these juveniles, and so juveniles won't be able to go rush in and buy a rifle. There will be a 3-day waiting period, and then that can be expanded up to 10 business days, which in reality is actually 14 real days because business days don't include the weekends. And so, and if there's any kind of already disqualifying characteristic that comes up in the search of the juvenile record, so it doesn't create a new disqualification with the juvenile records. It says that if the juvenile records turn up something that is already disqualifying under 18 U.S.C. 922, then they're disqualified. So that means that if they've been adjudicated as committing a felony or they've been involuntarily committed to a mental facility, something like that. So it doesn't really create a new disqualification. It just simply expands the ability to ferret out whether or not a disqualification already exists. Now, this is where I see the possibility of them expanding that in the future. So I think it is highly likely that after a few years, they will say, look, isn't this fantastic? This works so well for 18, 19, 20-year-olds. We need to expand it to everybody that their juvenile records are accessible. And I believe it's only juvenile records after they have become 16. I think that's the way that I read it. But so that is a possibility for expansion to everyone. But like I said, it doesn't really create a new disqualification. It just kind of opens up a new category of records that can be looked at for an existing disqualification. So that's what it does with regard to the 21-year-olds, which is, like I said, as opposed to the bill that came out of the House, which wanted a hard prohibition, no 18, 19, 20-year-olds can buy a rifle, period. And so that is obviously in the nature of compromise. The next thing that it does.
Before you go to the next one, I want to make sure I'm clear on this one. So this means that if you're 18, 19, or 20 years old, there's a possibility you may get delayed up to 10 business days.
That is correct.
Okay, and then they also get a chance to look into your criminal history.
Well, your juvenile history.
Juvenile. Okay, got it. Juvenile history.
Yes.
Okay.
So to see if as a juvenile you were ever adjudicated for a crime that would have been considered a felony if an adult had done it, or if you had been committed to a mental health facility as a juvenile. And so what's interesting about that is that this particular procedure requirement is supposed to exist for the next 10 years, and within this 10-year period, the government is supposed to begin integrating those records into the regular NICS background check. So after 10 years, it will go back to being just a regular NICS background check, but it will include all of these juvenile records. So the delay period is only going to exist for 10 years, and then the law assumes that after 10 years, the records will be fully integrated, and it goes back to being an instant background check, so there will be no waiting period. You'll either get your deny or proceed fairly immediately.
Okay. And that's from the ages of 18 to 20?
18, 19, 20. However, like I said, with that caveat that I absolutely can see the Democrats coming back and saying, this worked out fantastic. Let's just apply it to everyone.
Got it.
So I do believe that that is one of the Trojan horses that is built into the bill that will eventually impact everybody who does have one of these records. Like I said, if you're an adult now and you don't have one of these records, then you've got nothing to worry about. Like I said, there's no new prohibition that's being created that you would have to worry about. Okay. So now, in the realm of prohibited persons, this bill also closes what everybody has been calling the boyfriend loophole. And believe me, I hate that term. I hate the way that anytime whenever you talk about gun laws, they throw in the word loophole, because just, as we know, as a general principle, every single gun law that exists has been a compromise on behalf of the gun owner. So if you want to just, get in your time machine and go back to 1933, any adult could go into a hardware store and purchase a fully automatic Thompson, 1921A rifle and have no interference from the federal government whatsoever. So everything from that time period, every federal law from that time period forward has been a compromise to chip away at that ability that we had in 1933. So every single federal gun law is a compromise. And as, we like to say around the office, yesterday's compromise becomes today's loophole. And so that's why I hate the word loophole, is that there was a reason that that dating violence, boyfriend, not being able to access dating relations, not considering assaults that occur while people are dating is not family violence. There's a reason that was not included way back whenever the family violence provision was made. And that's because it's extremely difficult to define what that is. And so, since then, the anti-gun folks have been saying, oh, my God, they allow domestic abusers to have guns. So this presumably addresses that. Okay. So what that says is that if an individual has been convicted of a misdemeanor crime of assault, so keep in mind, I want everybody to remember, if you're convicted of a felony, you're totally prohibited already. So it doesn't matter what crime it is. If it's a felony, you're a prohibited person. So this specifically only addresses misdemeanor crimes. So if you're convicted of a misdemeanor crime of violence, it could be an assault, maybe a terroristic threat. It's just defined as a crime of violence. You're convicted of a misdemeanor, and it turns out that the complainant or the victim in that crime meets the definition of you being in a dating relationship with them, then you're a prohibited person. You become a prohibited person.
And this is for life?
No.
Okay.
That's the interesting part.
All right, hold that thought, Evan. I'm gonna let you finish that on the other side of the break here. We come back, we're talking about the new gun legislation that's going to go into effect. Edwin's going to tell us when this is going to go into effect, and he's breaking it down for us right now. This is Michael Cargill, and you are listening to Come and Talk It.
Hi, this is Stephen Williford, the Barefoot Defender. I get my global gun news from Michael Cargill at Come and Talk It.
I'm a U.S. Army veteran with a strong sense of duty and respect for our system of government. After 12 years, I was honorably discharged and decided I would fulfill the American dream of entrepreneurship and open up a gun shop in Austin, Texas. At my shop, I teach people to be law-abiding and how to safely use their firearm. On page 46, we're going to talk about Penal Code Section 46.02. The day that ban went into effect, I went into my local ATF in Austin and turned over my Bumpstock because I'm a law-abiding citizen. But I wasn't going down without a legal fight. So that's why I reached out to NCLA.
NCLA is representing Michael Cargill because federal agencies do not have the power to rewrite statutes. Bump stocks are not machine guns. If Congress wants to change the law and ban bump stocks, it certainly can do so. But we can't have the executive branch rewriting a statute and putting people in jail for up to 10 years.
It's a problem because, this government agency has said, you know what, something that is legal is now illegal, and we're going to confiscate it from you, and we're not going to compensate you for it, and you're going to become a criminal.
The goal of our case here is to tell the ATF that they can't get away with this kind of administrative lawmaking. This isn't constitutionally permissible, and this goes against everything that our nation was founded on.
The bump stock ban turned innocent law-abiding citizens into criminals overnight, even though they were compliant with the statute. And that's not right.
This case is not about where you stand on bump stocks. It's about the rule of law. It's about whether an agency can rewrite a statute and turn.
Welcome back to Come and Talk It. And now here's Michael Cargill.
All right, we're talking with Edwin Walker with Texas U.S. Law Shield, and he's telling us about the boyfriend loophole. Edwin, what in the world is all this all about?
Well, like I said, the boyfriend loophole existed because of the fact that they didn't want to include it in the original bill back in the 90s because it's so difficult to define. And, if you read the definition now, it really doesn't get any better. Pardon me. Although it does say that, social relationships and business relationships don't count. And there does have to be some sort of extended and frequent contact between the people who are involved in this relationship. Now, keep in mind, Texas has had this dating relationship family violence for well over a decade now. And, it's still kind of a fact issue. So if you have a case where the police and the prosecutors are accusing you of assaulting your girlfriend or girlfriend's accused of assaulting a boyfriend, that's a fact question. And so, the court will have to look at things like how long have you seen each other, how, to what extent is your physical relationship. There may be evidence from other people who are like, oh yeah, they've been boyfriend and girlfriend for quite a while. So it is kind of amorphous. Obviously, determining whether or not somebody's married to another, that's black and white. It's yes or no. Whether somebody's kid, that's black or white. That's yes or no. The dating relationship stuff can definitely be shades of gray. But what this bill does that this determination of the relationship does, what the original law should have done is that it provides, pardon me, it provides that this statute is not retroactive, which is fantastic, really, because that's where a lot of people that are denied because of this, because of this domestic violence prohibition, is that the courts and the FBI and the DPS, when issuing licenses to carry, they're able to go back indefinitely to find out, to investigate whether or not a misdemeanor, if somebody was convicted of a misdemeanor assault way back in 1985, was the victim of that. This was even before they defined crimes of family violence. If the victim of that assault happened to be a person's spouse or a person's child, they're prohibited now. It really rang as a violation of due process, as an ex post facto law.
All right. So hold on a second here, Edwin. So you mean to tell me that when this goes into effect, that if you did something 10 years ago, 20, 15 years ago, that can prohibit you once this goes into effect?
No, that's the way the law exists now with regard to the family violence prohibition.
Okay.
And that's one of the big problems, is that people who were convicted of an assault, a misdemeanor assault 20, 30 years ago, can find themselves being a prohibited person, and they have lived an absolute clean lifestyle for the last 25 years, but they find themselves in the category of the prohibited person. This closing of the boyfriend loophole specifically states that this prohibition cannot be applied retroactively. And that's fantastic. I wish they would have done it. I wish this had been part of the original law. Unfortunately, they didn't expand it to people who are already prohibited. But this boyfriend loophole, and like I said, I really hate using that word, is going to be closed from here going forward. It will not be able to apply retroactively. So
this is really not as bad as we think it is. This entire bill.
Correct. And like I said, if they would have just written it a little differently to say, look, we're going to apply this no retroactivity to the application of the entirety of the domestic violence prohibition, there'd be a lot of prohibited people that would have been leaping for joy because they would have now been eligible to purchase and possess firearms. Unfortunately, that's not the case. Another provision that should have been in the original law, but is now only applicable to the closing of this boyfriend loophole, is that this prohibition only lasts for 5 years. So unlike the law as it exists now, where you not only can be a prohibited person based upon a crime that you committed 25 years ago, but you're prohibited for life from ever purchasing and possessing a firearm. Here, if your prohibition is as a result of this closing of the boyfriend loophole, if you do not get in trouble again for another domestic violence conviction, then you're prohibited for 5 years. But then after 5 years, you regain your ability to purchase and possess firearms.
Okay.
So that, I mean, as far as, because this is one of those points that the anti-gun folks just they get up and they clamor about it and they try to demonize us people who are in favor of self-defense, in favor of the Second Amendment, saying you allow domestic violence people to have guns, and if this can shut them up, then that's a win in my book, because the damage that it can inflict on an individual is very minimal, and now people should be on notice that if they do wind up in a state criminal court accused of a misdemeanor crime of domestic violence that allegedly involves somebody that they were quote unquote in a dating relationship with, they better get an attorney and they better fight it.
Okay. All right. And then anything else in that bill? And also, when does it go into effect?
Yes. So, sorry. So the provisions of it, I mean, especially the spending and everything, it doesn't have a delay like Texas law does. Texas law always specifies at the end of the bill, this will go into effect September 1st. This will go into effect January 1st. Federal law, whenever U.S. Congress passes a bill and the president signs it, it's immediately effective.
Oh, wow.
And so, so the ATF is probably going to be sending out these new, they probably already have their regulations promulgated.
This means we're going to have a new 4473, a firearms transaction record.
Yes, there will have to be some modifications to it.
Wow.
Now, it's interesting that you bring that up because those are the other two provisions that affect the transactions of firearms, is that they have now strengthened the punishment and they've kind of narrowed the definition, which is actually a good thing, of what is a straw man purchase and what is considered to be gun trafficking. And so those are two things that, obviously if you don't make straw man purchases, then you don't have to worry about it. If you're not involved in gun trafficking, you don't have to worry about it. But they have really strengthened the penalties if you are accused and convicted of either one of those crimes. But like I said,
okay, hold on. So
clarity.
So which are what, Edwin? Because a straw purchase means that you go into a gun store and you're trying to buy a gun for someone else, knowing that person can't take possession of it. That's a straw purchase. What was the old punishment? What's the new punishment?
Well, what's interesting is that the Supreme Court held that the ATF or the Department of Justice, they don't have to show that the person you were buying the gun for was a prohibited person. So it's just that you went into a gun store and you bought a gun for the purpose of giving it to another person. I want to clarify that because people are immediately going to think, oh my God, I can't give a gun as a gift. No, you can. What the Supreme Court says is you cannot take somebody else's money. Basically what I analogize it to is, you buying beer for teenager outside of a 7-Eleven.
Correct.
So, you walk up to a 7-Eleven and there's a group of teenagers there and they're like, hey, mister, here's $20. Would you go buy a 6-pack of beer? That's a straw purchase, okay?
Right.
But if you're like, I'm going to go buy beer and I'm going to split it with my 20-year-old nephew sitting out by the pool, that's not a straw purchase.
Correct.
And so the same thing with guns. So if you take somebody's money and you buy them a gun, and you're the one who fills out the 4473, and you're the one who states on there that you're making the purchase for yourself, and you lie about that, you go, yes, I'm purchasing it for myself.
Right.
That's still a crime. That's still a straw purchase. But there are now enhanced penalties if the ATF finds out that you were specifically buying it to give to a prohibited person, knowingly doing that, or you were doing it to sell to somebody that you believe, that is going to commit a crime, and it really, really focuses in on drug trafficking, terrorism.
This is really big, and people don't understand how big that really is. That happens a lot in the gun stores.
Well, and that's the thing about it is that I think we would all agree that we don't want people giving guns to terrorists and drug cartels.
Correct.
I mean, I would think that's a sensible position.
Correct.
And this law, it is kind of funny because just in case you were wondering, just in case anybody was unsure, this law now specifically says that it is prohibited to provide firearms and ammunition to an agent of a drug cartel. So that is now a specific dictated prohibition.
And you don't even have to know they're members of a drug cartel.
And the thing about it is that this may have been like kind of the Republicans sticking that in there to give to thumb their nose at the old Fast and Furious scandal that happened under Obama. It was like, look, the ATF specifically gave guns to the drug cartels. So that exists. And it also now says that if you are, if you're accused of giving guns and ammo to drug cartels, drug traffickers, potential terrorists, that this now is also can be punished as under the money laundering laws and under the organized crime set, the RICO statutes. So they've really expanded the ways that this particular type of offense can be prosecuted and enhanced the punishments for it. So we've got the straw man purchase, we got the trafficking, and the last thing that it does is it, is that it expands, and this kind of dovetails with the straw man purchase and with the drug traffic, with the gun trafficking, is that previously unlicensed dealers, in order to prove that somebody was an unlicensed dealer, the Department of Justice would have to show that they were motivated in dealing guns by either doing business or seeking to make a profit. And so they felt that was a little too amorphous. Unfortunately, they defined it, and it's still kind of the same amorphousness. They just said if you make a profit, so if you sell a gun with the primary purpose to make a profit, then they can prosecute you as a gun dealer. It doesn't matter how many guns there are. Now, obviously, the scary story would be, if a gun is going to be particularly valuable in the future and you buy it sort of quote unquote as an investment, and, sure enough, let's say it's some limited edition model that Colt is going to, and which people do that all the time. I mean, I've got several Colt commemorative firearms. I bought them with the hope that they will go up in value. So if I, one of the ones I've had is a Colt firearm, commemorating the battleship Texas. So, and I know that there were only 1,500 made. So if I bought one of these battleship Texas 1911s, there's only 1,500 made. Somehow they become extraordinarily popular in the collectible market, and I sell it. Am I now a gun dealer because I knew that it was going to go up in value, or at least I hoped that it would go up in the value, and then I would sell it? So that is a little scary. But what is interesting is the Department of Justice no longer has to prove profit motive if it turns out that the guns that you have sold in the past turn up at crime scenes. So if your guns, and I'm assuming that they're going to, as a practical matter, as a factual issue, there will have to be some sort of, time period limit.
Right.
So let's say that a year ago you sold 5 guns because you were like, I don't want these more, I have 5 guns. And 3 of those guns show up at different crime scenes.
And we're going to go to break, Edwin, so go ahead.
Okay. One's at a liquor store robbery, one's in a carjacking, that if they're able to say, wow, your guns that you sold have shown up at crime scenes, we think we can show you're an illegal gun trafficker because you specifically sold these to people you should have known, or we're gonna try to build a circumstantial case to show you knew they're going to commit a crime. They do not have to prove the profit motive element.
All right. We come back from the break. We're going to talk about the Texas GOP, Law and Republicans of Texas. We're going to talk about this homosexuality plank. We're also going to talk again with Evan Walker about New York State and what SCOTUS said about New York. This is Michael Cargill, and you are listening to Come and Talk It.
Peace. This is Maj Toure. You're listening to Come and Talk It Radio with Michael Cargill.
Whether it's a typical traffic stop or you're just involved in a use of force incident, encounters with law enforcement can be scary and stressful. In the heat of the moment, you may inadvertently say something you don't mean or make an inconsistent statement. These are red flags for officers, and if they think you're lying or your story doesn't add up, they might arrest you and let the criminal justice system decide your fate. Police officers are trained to get information from you without making the interaction seem like a formal interrogation. But remember, from the moment an officer arrives on scene, everything you say and everything you do will be scrutinized in court. The prosecuting attorney will attempt to use anything and everything against you. So what do you say? You say, I invoke my right to remain silent, and then let your attorney interact with law enforcement on your behalf. One important note though, do not throw common sense out the window. For example, if the intruder's hiding somewhere in your house when the police arrive, or if you saw the perpetrator pitch his weapon into your backyard, quickly tell the police and then stop talking. You might ask, what about my rights? What if the police never read me my Miranda rights? Miranda rights is the common name for a collection of rights contained in the Miranda warnings, given to suspects when they're placed under arrest. The warning comes from a 1966 Supreme Court case, Miranda v. Arizona. In that case, the court held that statements from a custodial interrogation would not be admissible unless proper procedural safeguards were in place to protect the defendant's Fifth Amendment rights. We've all seen these warnings on TV and movies. You have the right to remain silent. You have the right to have an attorney. Anything you say can and will be used against you in a court of law, and so on. So do police have to read you your rights? No. It's important to note that officers are not required to read you these rights unless you're in custody and subjected to interrogation. If the police show up to a crime scene and start asking you general questions and you voluntarily tell them everything that happened, those statements can be used against you regardless of the Miranda warnings because you're not in custody. If you're put in handcuffs but you say something incriminating on your own without being questioned, those statements can and will be used against you because you're not being interrogated. You're just starting to spout off. This is why it's imperative that you know your rights and you shouldn't rely on the police to read them to you. Affirmatively invoke your rights. Say, I'm invoking my right to remain silent and my right to my attorney. Once you do that, the police legally shouldn't continue questioning you without your attorney present. But remember, there's a second part to this equation. After invoking your rights, you must exercise those rights. That means you have to keep your mouth closed. Protect yourself. Don't let the legal system take advantage of you after an incident. And Law Shield members, if you've been involved in a self-defense incident, remember to call the emergency hotline and speak with your independent program attorney.
Welcome back to Come and Talk It. And now here's Michael Cargill.
All right, so we're back and we have inside the studio Jason Vaughn, who is a delegate at the Texas GOP. because the Texas GOP says homosexuality is an abnormal lifestyle choice. Now, you're asking yourself, why would I bring this up on the gun show to talk about this? Well, because I'm just curious who's going to walk into someone's house, into someone's bedroom. What government agency is going to enforce who can sleep with who? Because I tell you what, I got 45 reasons why you're not walking into my house. I got 5.56 reasons. I got 223 reasons. I got 308 reasons why you're not going to walk into my house and tell me what I can do inside my house. So I'm just curious, what government agency is brave enough to do this? So let me welcome to the mic here Jason Vaughn to tell us what in the world is all about this plank from the Texas GOP.
Well, I think one of the first things that we need to think about here is that this is not a policy. It has this is not telling the government to do anything. It does nothing for the party. It does nothing to say that the government should go and do this. The only thing policy related to homosexuality specifically is that the party is still anti-gay marriage, which is fine. It's been 7 years and there's never been a bill filed except for one in Mississippi that said that wanted to take government out of marriage completely and just make it civil unions, and that bill didn't even get a hearing. And so it's not like this is actually any of this stuff is going anywhere. This was something added in at the very last minute of the permanent committee. So the way the committee works is we have several different conventions. You have your precinct conventions, your Senate or county conventions, and then I was on the platform committee. That's made up of one of 31 people, one person representing each Senate district. And then we had our subcommittees where you break out into smaller groups to go through each section. Then you have your temporary committee, which is where we all meet as a whole. And then you have your permanent committee. It was not represented this language was not brought up in the subcommittee. It was not brought up in the temporary committee. It was brought up right after, in the last 40 minutes of the meeting, right after the chairman said that we were about to run out of time. He said, hey guys, we don't really have a lot of time to discuss anything. Oh, yeah, and I would like to make an amendment to the homosexuality plank, language that we have, that many people on both sides of this have fought over to try to make it more policy-oriented, to be clear about where Republicans stand without personally getting offensive. And the fact that this actually came from the chairman of the committee made it all worse. He gave us no warning. One of the things we've tried to do on that committee is be very respectful to each other, even when we deeply disagree, because you're working very closely together for 4 days. So if you know you're going to have a disagreement with somebody, you go to that person and you say, hey, I just want to give you a heads up that this is going to happen. The chairman knew I was the only openly gay person on that committee. So he could have come to me and said, hey, I want to talk to you about this. I want to try to work out language, whatever it could have been. But he did none of that. The whole process was extraordinarily disrespectful to the entire body.
And it's strange to me that we didn't discuss the grid. Let's talk about, strengthening our power grid. Those are some of the things we should have focused on when it comes to like policy or getting the state of Texas to actually, getting our elected officials to concentrate on, because we had a snowpocalypse and had some serious issues. So, that I think that energy should have been focused more on that stuff, more that direction.
I do believe the grid's actually in there. It is, but 200 and it's 275 planks total. Mm-hmm. So the problem with this language is that it's a distraction. It's a distraction that does not win Republicans a single vote. If you're already extremely anti-gay, you probably already know that the Republican Party is going to be your home. If you're like, we have plenty of stuff that's in there policy related to that. It didn't get us any votes. All it's been for well over a week now is a campaign and a fundraising resource for Democrats. The chairman came up to me later on and said, I just want you to know this was nothing personal. I wanted us to be clear. And as I told him, this did nothing to do for clarity. It has been nothing but a distraction for the entire party. Beto O'Rourke is loving this plank right now.
And I'm sure it's gonna, we'll see what happens if the Republican Party actually loses seats. Because if that happens, then they're definitely going to change gears in 2 years.
No, look, I think I got to be honest, and I think we have to say that the Republican Party's, look, after this week, after another 2 weeks, nobody's going to care. They're going to care about inflation. They're going to care about all this. This does nothing on those fronts, but it did give it's not going to change policy. It's not going to change a lot of voters either way, but it is going to change the fundraising.
It's not going to change voters, but it's going to keep, some people will sit on their hands instead of actually going to vote for certain candidates. And
Yeah,
that's
because
gonna
it's not just gay people. It's all people that have gay family members, people in their lives that are hearing about this. Those are the people it really does affect, and they'll be like, well, what's the point of this? But again, the party is not very effective in any of this going forward policy-wise.
Right. And then there's a lot of resignations that actually took place this week. I was the actual chair for Law-Abiding Republicans of Texas. I resigned. And, man, it was crazy because some media outlets took that to mean that I was upset because of this particular plank. There's so many planks, that the GOP actually has. This is just one particular plank. This had nothing to do with me resigning from Law-Abiding Republicans of Texas as the chair. The reason I resigned from LCR Texas was because of the influence that some members that came from California have moved here to Texas, and members in D.C. are trying to influence Texas and tell Texans what we can and can't do. And, this is Texas, the Lone Star State. We're not going to allow someone to come in from another state, definitely not Washington, D.C., and definitely not some of these GAYs from California to tell us what we can do here in Texas. I wanted to say something else, but I'm on live radio, so I can't. Started with the F. But I'll digress.
No, and I think you're seeing a lot of changes in different organizations, but I think the good thing is you're also seeing a lot of different things pop up, like Marco Roberts, the former who had the presidency of Texas LCR before yourself, has now formed Texas Conservative Liberty Forum, something I'm on the board of as well. We're going to be a very policy wonk-oriented place, and I think there's a lot of good things coming. I'm personally about to launch my own organization called The First 90, which is focused on recidivism, and I'll be working with our police officers, parole officers, criminal justice reformers, helping non-violent, non-sexual criminals really find a place back in the world and be restored after their time in prison.
And I tell you what, there are a lot. You're right. There are a lot of great organizations that have actually popped up since the convention, or just before the convention actually started, that are doing great things. And I guarantee you, unfortunately, I think LCR Texas is going to be disbanded. I think that board is going to go away completely because, once you lose, some of your backbone, you're not going to be able to stand up anymore. And it's going to collapse. The walls are going to fall down. And you're going to see this within days, if not weeks.
Well, the good thing that I would remind people is while that the LCR Texas may be going away, if you are a friend, if you're an ally or you happen to be gay, that Austin still has a very strong log cabin that you're staying the president of.
That's right. Still the president of Log Cabin Republicans of Austin.
And then San Antonio, Mimi she's just amazing.
San Antonio rocks.
She's fantastic. So I have to give her a lot of props.
All right, we come back from the break. I do want to talk about New York. I do want to get back to talking about the Bumpstock ban. We're going to talk about that again. So we got a lot. Hang in there. This is Michael Cargill, and you are listening to Come and Talk It.
Yo, what's going on, guys? It's Jack Jones here, and I get my gun news from Michael Cargill on Come and Talk It.
Hello, my name is Edwin Walker. I'm an independent program attorney with Texas Law Shield. I want to talk to you today about an issue that we see on a daily basis. In fact, you yourself will encounter it on a daily basis, and that is the subject of road rage. I am sure that you have all seen road rage. You may have actually been involved in a road rage incident. Now, if you're a responsible gun owner, I'm going to give you a few words of advice on how to react when you find yourself in one of these unfortunate road rage incidents. While on the roadways, we all observe something that makes us upset. Whether it's poor driving, unsafe driving, or just simply somebody being very discourteous. By all means, you should restrain yourself from engaging that person and telling them how bad their actions were, because this can be perceived as an act of road rage. If you're a lawful gun owner, you have a firearm in your vehicle, you do not want to be viewed as the aggressor in a road rage situation. Now, with regard to a situation where an individual has chosen to rage against you, and you are the actual victim of the road rage, if you and the other individuals are still in their automobiles, do not use your firearm to respond to any of the rager's activities. This is because law enforcement views the fact that you're both still safely in your metal boxes as removing any threat of immediacy that you may be harmed. So please, if you have a gun, somebody is raging against you, forget you have a gun. Don't display it, don't brandish it, don't show it, don't point it, and for God's sake, don't fire it. This could result in a lot of trouble for you. Now let's look at a situation where a road rage incident has escalated. It has escalated to the point where one of the participants has actually gotten out of their vehicle. We recommend that you stay in your vehicle at all times. Do not exit your vehicle, because the person who exits their vehicle is going to be looked at as the aggressor. If the other individual has exited their vehicle and they are not in contact with your vehicle and they do not have a weapon, then do not feel that you can display your weapon in an act of self-defense. People are allowed to just simply stand there and scream at you, scream whatever they want. Until they make a demonstrative effort to try to harm you, there is no immediate threat that would justify displaying or shooting or brandishing your firearm. Now, in the event that the person shows their own weapon, in particular a firearm, the existence of their weapon would give you reasonable belief that there was an immediate threat of harm that would justify an act of force or deadly force. Even in this situation, I would be very cautious. Now, if this situation escalates even further, where the person has actually made physical contact with your vehicle, whether they are beating on it with an instrument, with their fist, or they're attempting to open your door, this would give you the facts that you would need to show that you had a reasonable belief that that individual was unlawfully and forcefully attempting to either enter your vehicle or remove you from your vehicle. This is very, very important because this falls under what is commonly known in Texas as the Castle Doctrine. The Castle Doctrine provides that an individual is given a presumption.
Welcome back to Come and Talk It. And now here's Michael Cargill.
So listen, the platform also included a section calling homosexuality an abnormal lifestyle choice. You are an out gay committee member. You voted against it, including that, right? And called it disrespectful. So why did the Texas GOP approve this plank for the platform?
I think there got to be a lot of confusion on the floor. If you look at the way the body voted versus the way the committee voted, the committee was very close. It was 17-14. If we'd have flipped 2 votes, that would not have gone in there. And look, I understand my party does not believe in gay marriage. That's a policy issue we can debate. The problem with this language was it was insulting and it is distracted from so many other planks that I do care about. If you listen to the debate on the floor of the convention, you'll see that right after this was passed, this abnormal gay guy got up to the mic and actually was able to suspend the rules and put in extremely important information on a plank on protecting fragile children, making sure they have home care, community-based care. And that's something that Republicans should be talking about, uniting under. There are 275 planks, and the only ones we're talking about 4 of them that are complete and utter distractions that make, for most of them, I disagree.
All right, that's Jason Vaughn, and I tell you, he went on CNN up against Don Lemon there and did an outstanding job defending the Texas GOP and just his stance on his thoughts on how things played out in the convention. So I just want to tell you, Jason, outstanding job. Really want to congratulate you. You did a great job, because there are a lot of people out there, like the person that was on the committee that actually wrote the plank to talk about homosexuality is abnormal, was a coward and refused to go, to talk to the media to defend why he actually suggested or wrote this plank.
Yeah, well, I think it's very important we start and getting Republican voices out there, and Republicans that are, if it's your first time ever doing an interview, I highly would not recommend going on national television. But we need more bold people that can stand their ground, because look, Don pushed back pretty hard trying to get me to say some things that he wanted me to say. But I know where I stand. I've never been ashamed of where I stand. And I'm not ashamed of being a Republican, so I was able to do all of those things, and I was able to get a nuanced point of view out to say, yes, I highly disagree with this, but here's why I'm a Republican. And I was very happy to talk about, especially being from Harris County, talk about the bail issue we have there, where all these judges are consistently letting people out with low or no bail on violent crimes, and then they're just going out killing again.
Yeah, I tell you, we definitely do something with our district attorneys. That's a huge problem, but we're not focusing on that. We're talking about what's happening in people's bedrooms instead of what's happening with crime, the grid. Those are the things that we need to push and really focus on a lot.
Inflation,
asset forfeiture, those things like that, which is a really big problem. What are you gonna say, Gary?
Oh no, I was just in agreement.
Okay, yeah. So I think those are the things we definitely should focus on. Man, I tell you what, thank you, Jason.
Happy to be here. I appreciate it. And I'm always happy to defend what I believe.
Absolutely. Appreciate that. And you did an outstanding job this week. So don't let anyone think that what you did was wrong. It was outstanding. You defended yourself, because there are a lot of cowards out there that do things behind closed doors, and they're afraid to come forward and defend themselves. The person that wrote this plank, talk about homosexuality is abnormal, is a coward, because he he wouldn't come on any news agency at all and defend himself, because he's a coward. Just so you know. All right. So now I want to change gears and talk about New York State. So the Supreme Court came down with a ruling with New York State. And so now they are a what?
They are shall issue.
Not a what? Not a
may issue.
Not a may issue. And then someone asked, the Supreme Court decision makes it so states cannot do their permit as may issue, but instead they have to do the shall issue. And they want to know, Edwin Walker, does the new Supreme Court decision affect these new gun laws that we're talking about?
Well, that's going to be kind of interesting. So let's talk about what the New York decision, the New York State Rifle and Pistol Association case actually does, is that on a practical level, it does say that New York's discretionary may issue scheme, where people had to show a proper purpose in order to get a license, that is an unconstitutional violation for people who would otherwise be qualified. So as a practical matter, it just says that singular program in New York was unconstitutional as it worked. Now, this was a great decision, because for a decade, a little over a decade, we have been clamoring for the Supreme Court to make a new Second Amendment decision. They had been avoiding it, pushing it off, finding ways to not rule on the subject. And in the meantime, lower courts had found that California's may issue was permissible. New York's may issue was permissible. New Jersey's may issue was permissible. I believe Connecticut's may issue was permissible. And so it was about time that the Supreme Court made this decision. So its immediate purpose says New York's may issue scheme unconstitutional. This then puts notice, gives notice to those other states that their may issue schemes are probably also very likely unconstitutional, so they'll have to revise those. But what it does is that Heller, the Heller and McDonald decisions, they basically said that you have a fundamental right to possess a firearm for self-defense inside of your own home. Pardon me. And that was the part that the anti-gun folks focused in on, is that they said, well, Heller only said you can have a gun in your own home, so therefore we can regulate whenever you go out in public with it. And because that's the way the constitutional rulings work. The Supreme Court is not a super legislator. They can't dictate what what the law should be. All they can do is address particular laws that are in front of them and decide whether or not they are unconstitutional and what sort of fundamental right that they implicate. Well, Heller and McDonald implicated the right to have a gun, possessed inside your house. So that's all they were allowed to rule on. This now implicates a gun being carried outside the house. So now there's a new recognized Second Amendment right that's been officially recognized by the court, and that is the right of a person to carry a firearm outside of their house for self-defense purposes. And so now any law that exists in the federal, state, or local governments that affect that or impair that will now be subject to being scrutinized by the courts. And also, Heller and McDonald did not officially set forth a standard because whenever you're looking at constitutional rights or the way that a law works, it can be judged under one of three standards. The rational basis, did the legislative body have a rational basis for making this law? Those do not affect constitutional rights, so those are always generally upheld. On the opposite end of the spectrum is strict scrutiny. If the courts determine that a piece of legislation affects a fundamental constitutional right, then the courts will look at that to say, does it affect a right? If it does, it cannot be upheld. So those almost always fail. And then there was this intermediate scrutiny where it might go one way or another. Actually, this case kind of creates a new type of scrutiny specific to Second Amendment issues. It recognizes that the Second Amendment is a core constitutional right. It is not a secondary right. It's not a second-class right. It deserves to be it deserves to be looked at with the same veneration that we view our First Amendment rights, and that any regulation is going to be viewed as through this prism as if has this been a historical area that has been subject to regulation. And I think as a practical matter, very few regulations will be able to withstand that scrutiny.
All right, listen to New York City Council as they whine about what they're going to do as a result of this Supreme Court ruling.
In light of today's ruling by the United States Supreme Court in this case, we cannot idly stand by and just watch our streets be flooded with guns due to more people being permitted to legally carry firearms in public. We must take significant action to protect our city's residents. When New Yorkers are being victimized by gun violence due to the soaring influx of legal and illegal guns, putting them even more firearms into the hands of people in public spaces, that will have dangerous consequences. Our proposed solution encourages the state to tailor a law that accounts for New York City's high population density as a factor in establishing specific parameters for the definition of sensitive areas where legal firearms are prohibited from being carried by members of the public. The ability to designate sensitive areas where citizens are prohibited from carrying concealed firearms is a framework that is still respected by the highest court and one to be utilized to prioritize public safety. Prohibiting the possession of legal firearms in sensitive facilities such as hospitals and poll sites is not only good for public safety, it's just plain common sense.
What a concept. People should be able to defend themselves from being assaulted, having things like murder. What a concept. Robbery, aggravated robbery, theft during the nighttime, criminal mischief at night. You should be able to defend yourself. You should be able to defend yourself inside your home, outside your home, in your vehicles. You're driving down the road. And these people, this city council is whining because people don't want to be victims. This is Michael Cargill, and you are listening to the Come and Talk It.
This is Brittany Glaze, and I get my global gun news from Michael Cargill on Come and Talk It.
Whether it's a typical traffic stop or you're just involved in a use of force incident, encounters with law enforcement can be scary and stressful. In the heat of the moment, you may inadvertently say something you don't mean, or make an inconsistent statement. These are red flags for officers, and if they think you're lying or your story doesn't add up, they might arrest you and let the criminal justice system decide your fate. Police officers are trained to get information from you without making the interaction seem like a formal interrogation. But remember, from the moment an officer arrives on scene, everything you say and everything you do will be scrutinized in court. The prosecuting attorney will attempt to use anything and everything against you. So what do you say? You say, I invoke my right to remain silent, and then let your attorney interact with law enforcement on your behalf. One important note though, do not throw common sense out the window. For example, if the intruder's hiding somewhere in your house when the police arrive, or if you saw the perpetrator pitch his weapon into your backyard, quickly tell the police and then stop talking. You might ask, what about my rights? What if the police never read me my Miranda rights? Miranda rights is the common name for a collection of rights contained in the Miranda warnings, given to suspects when they're placed under arrest. The warning comes from a 1966 Supreme Court case, Miranda v. Arizona. In that case, the court held that statements from a custodial interrogation would not be admissible unless proper procedural safeguards were in place to protect the defendant's Fifth Amendment rights. We've all seen these warnings on TV and movies. You have the right to remain silent. You have the right to have an attorney. Anything you say can and will be used against you in a court of law, and so on. So do police have to read you your rights? No. It's important to note that officers are not required to read you these rights unless you're in custody and subjected to interrogation. If the police show up to a crime scene and start asking you general questions and you voluntarily tell them everything that happened, those statements can be used against you regardless of the Miranda warnings because you're not in custody. If you're put in handcuffs but you say something incriminating on your own without being questioned, those statements can and will be used against you because you're not being interrogated. You're just starting to spout off. This is why it's imperative that you know your rights and you shouldn't rely on the police to read them to you. Affirmatively invoke your rights. Say, I'm invoking my right to remain silent and my right to my attorney. Once you do that, the police legally shouldn't continue questioning you without your attorney present. But remember, there's a second part to this equation. After invoking your rights, you must exercise those rights. That means you have to keep your mouth closed. Protect yourself. Don't let the legal system take advantage of you after an incident. And Law Shield members, if you've been involved in a self-defense incident, remember to call the emergency hotline and speak with your independent program attorney.
Welcome back to Come and Talk It. And now here's Michael Cargill.
All right, so we got a couple questions for you there, Edwin. So we'll see if we can cover all this stuff in like 7 minutes or so. All right, so the first question, Edwin, is gangbangers have been illegally carrying for generations now. So what is new? Good guys can now carry? Okay, he dropped. Okay. No
Okay,
worries.
I've got a quick question for Zach.
Yes, sir.
Because I think he could explain it in the layman's terms.
I'm a lame man.
Can you explain what the difference between a may carry state and a shall carry state is?
So states have permits, right? Like Texas has the LTC, the license to carry. And Texas is a shall issue state for their permits, which means that if you apply for a permit and you don't have a felony on your record or anything that would bar you from getting a license, then you get a license. In a may issue state like New York, California, some others, and Hawaii, they basically say, you know what, you need to tell us, the government, why you need a gun, and you need a really good reason.
So what is some criteria that determines whether or not you may get a permit?
Oh, like if you're famous or if you're rich.
Or a politician.
Or politician, yeah. They will all get a permit.
So to me, what this sounds like is that the may carry states are engaging in a form of elitism.
Yeah.
Okay.
I think you're right about that.
And that is not fair, and it's also not abiding by the Second Amendment.
Yeah, so you can go into those may issue states and you say, oh, I'm rich and famous. I need a gun to protect myself because I'm so rich. I'm so famous that people, they're going to come after me because I'm special.
Essentially, states that engage in may carry permit laws are disenfranchising poor people.
Exactly. Yeah.
And also, gun makers are fleeing the Northeast, complaining about the region's tough gun laws. So they're moving out of the Northeast in droves. You have, the signature weapons that powered America's wars, from the muskets of 1812 to the M1 Garand of World War II to the M16 in Vietnam, were made by millions in the Northeast. And now all those companies are leaving the Northeast, taking their tax dollars and moving to the central part of the United States, the southern part of the United States, where they're moving those tax dollars away from the Northeast. And that is really big. Places like, especially like California, a lot of people are moving out of those states like that, and they're losing those tax dollars.
Yeah, California has a huge state income tax, too.
Yeah, they're losing their congressional seats as well. And those, we've gained seats here in Texas because we have more people moving here to Texas. Mm-hmm. That can be good, that can be bad. What else you got, Gary?
Thomas Harrison asked in the chat, how is it possible that red flag laws pass constitutional muster?
That's going to be a question for Edwin. We have to get him back on one day. Yeah, we have to get him back on.
He's not on the line anymore?
Yeah, we'll get him back on another time to talk about that.
I think the short answer is that they kind of don't.
Well, what Edwin said during our panel when we did the show at the shop, he basically said when there's a search warrant, the police bring the cause to the judge, right, behind closed doors, and the judge signs this search warrant, and the person is not present for that, and so not everything has to have due process, is how he explained it. Like, you're not there for the search warrant getting
signed. Is that constitutional?
You shouldn't ask me about
right,
that.
Right. No, that's where, when you pull that thread, that's where my mind goes.
Uh-huh.
The only other thing I was going to ask about is if we want to talk more about the Bumpstock lawsuit. I mean, are we going to the Supreme Court, baby?
Oh, we're going.
We're going, baby. I love it.
You're definitely going. But check this out. You hear this story in Houston, Texas, where this man goes into a gun store in Texas, in Houston, and tries to rob the gun store at knife point and gets shot.
Well, you know what they say, Michael.
Huge surprise.
Don't bring a knife to a gunfight.
Don't bring a knife to a gun store.
Gun stores, employees at gun stores literally are waiting for you to do something like that. Literally. It's like, oh, wait, hold on, guys. There's someone at the front that's robbing us right now.
Yeah, I know some gun store employees that are just strapped to the nines.
You're right. I'm telling you right now.
Yeah.
Extra mags.
I know who you're talking about.
I know a guy that works at a gun store that has literally 4 of the exact same pistol on him at all times, including 5 extra magazines and 5 knives.
Is it who I'm thinking of?
Just waiting.
I think so.
Wait.
He's employee of the month every month.
They're sitting back there and say, hey, well, hold on, wait. So you're telling me that you're coming to the gun store to rob us right now? Well, I tell you, I just don't get it. And then, Gary, what's all the talk about, Roe versus Wade? Want to talk about
What's
that?
up with Roe versus Wade?
What's up with Roe versus Wade?
I don't know who Roe is. I don't know who Wade is, but I guess it made a lot of people angry. Whatever they did.
You want to talk about it?
I don't have much of an opinion on it. I'm more of a leave me alone kind of person.
Yeah.
So basically what happened, in order to explain
happened?
This to you, Michael, basically the Supreme Court says that the federal government does not have a say over these women's bodies.
Right. And that it should be left up to the state.
Correct.
Okay. Kind of makes sense.
Wait.
That kind of makes sense.
So that's really just that's just what's that called? The idea of federalism. So really striking that down is supporting the political idea of federalism.
Because all I heard come out of this was, man, you're telling me, as I'm sitting in the bar trying to enjoy my Long Island iced tea, you're telling me that guns have more rights than women's bodies. Is all I've been hearing for
I've
the
heard
last 2
that
days.
too. That's a sort of a misinterpretation of it.
No, it's not.
So I guess
No,
if
it's
you have a
guns
felony,
don't have any rights at all.
Actually,
you could sort of argue gun owners have more rights, but that still doesn't really apply.
you have to pass a background check to get a woman's body.
I mean, you know how women are these days. They Google you. They look my.
But anyway,
I have no problem with it personally. I don't care if women, they can do whatever they want.
oh, okay, that's the story, and he's sticking to it. We'll see.
What?
We'll see in about an hour or two.
What is that supposed to mean?
You'll change your mind.
I'm pretty honest on air.
Okay. All right.
I'm not hiding anything. Are you hiding something?
No.
Well, you don't really care because you're not into you're not into women.
Don't care at all. Don't care at all.
What about you, Zach?
I mean, it's up to them, you know.
Yeah, that's kind of where I'm at.
All right. What's this gun insurance going on? What is all that about?
California has passed they're trying to pass it, but did it pass?
Tell me more.
Well, they're trying to pass a bill regarding gun insurance. They're trying to require all gun owners to have insurance, same way that every motorist has to have car insurance.
Okay,
I think it was just introduced.
Yeah, it hasn't passed yet.
Okay, yeah, I just saw that and threw it in the show doc. But that would be setting a precedent, would it not?
Yeah, and they lie about the numbers too, because there's a state senator in California that says guns kill more people than cars, and that's actually
Well, that's not even close to being true.
right. It's not true at all. They're just outright liars. She said the cost of gun violence shouldn't be borne by taxpayers, survivors, families, employers, and communities. She says it's time for gun owners to shoulder their fair share. So they're trying to require some type of insurance by gun owners if they're going to carry a firearm.
So look, back to the red flag law thing. Thomas Harrison said something interesting in the chat here.
Mm-hmm.
He said that red flag laws basically mean that the crime has not yet been committed. So now we live in a world of Minority Report. Like what did they call it in that movie? Crime detection or
Pre-crime?
Pre-crime, yeah. And I think that's a good point because there's a difference between getting a search warrant and not going through due process per se and just arresting someone based on hearsay.
Yeah.
It's totally different. So I don't think that's what we were saying earlier about that is
Because
a
Karen
totally
can
perfect
just
analogy.
call the local law enforcement
Right.
officer and say,
There's,
ooh,
if-
I saw a Facebook post.
If you want a walkthrough of it, the Firearms Policy Coalition has a pretty good sort of cartoon graphic on their Instagram, and it shows this guy Randy who has a gun. And he posts something with his son at the gun range, and then a Karen sees his Instagram posts and considers him dangerous, and then she calls the state police or whoever it is, and then they go arrest him in the middle of the night with no warrant or whatever, and you get another one of those situations like that nurse that was killed in that no-knock warrant.
Mm-hmm. Right.
It's the
Breonna
same
Taylor?
Breonna Taylor.
Right.
It's the same principle, yeah.
Right.
Would you agree with that, Michael?
Hey, I tell these people, hey, look at Florida. You have the Florida woman who shot and killed this man after he broke into her bedroom while she was asleep and attacked her on Tuesday morning. She could have waited for police to get there to save her. Instead, she took her own personal protection in her own hands. So that's kind of what we're talking about. You need to be able to, people need to be able to defend themselves.
Right.
And that's just it. But last thing about the bump stock ban. So yeah, we're gonna go to Supreme Court. We're going to Supreme Court. So we're gonna go before the Fifth Circuit, and Fifth Circuit is gonna side with us, and then it's gonna be up to the Supreme Court to decide what they want to do.
Yep. It's gonna be Michael Cargill versus the United States of America.
So we'll see what happens. We're going to the Supreme Court. And this case is big because what happens with this will affect triggers. It will affect everything else of what the ATF is trying to say. As always, more guns equals less crime. You go out there, you buy yourself a gun. You've been listening to Come and Talk It with Michael Cargill.